नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां आज हम आपके लिए लेकर आए हैं एक नया लेसन।
If you are entitled to obtain some remuneration. So the court judgments over the years have made a distinction between compensatory allowance for defraying out-of-pocket allowance expenses and remuneration. So if it is merely defraying your expenses, it's not an office of profit. You attend some meeting and you're given taxi fare, but you sit in the meeting and you are appointed to a position as a member, and then you are getting some sitting fee, even if it's 1 rupee. Even if you collect it and then say, I don't want it, it still becomes an office of profit. Now, the office of profit comes both for members of parliament, but importantly, office of profit also comes for as a disqualification for election of president and vice president. So if you look at Article 58, and look at Article 66. Just for a moment, just look at Article 58 and look at Article 56. A person shall not be eligible for election as president if he holds an office of profit under the government of India or the government of any state, but there is an added qualification here, or under any local or other authority subject to the control of the said government. Now, if you look at Article 58, and the analogous provision is for Vice President. And you'll notice the difference between 58 and 66 on the one hand, and Article 102 and 191 on the other. For 102 and 191, it's only Office of Profit under central government and state government, but there local and other authorities. What exactly is the significance of this? These four terms, central government, state government, local or other authorities, is very similar to the definition of state that we are going to study next semester in Article 12. And what is an example of a local authority? You could be a chairperson or a mayor of a municipality. That would be an office of profit. What is an other authority? Supreme Court has given a very expansive definition. Other authority are various statutory bodies which are discharging some functions which a state needs to discharge. Not just sovereign functions, it could be functions of an important nature like running a university. So becoming a member of the executive or a senate of a university technically would be an office of profit. Becoming a vice chancellor. Other authorities are vast and many. So Delhi University is another authority. Public sector undertakings are all other authorities which are having financial control, managerial control of the government. They are not part of the government, but there is sufficient control managerially or financially or functionally. That is, it's a separate entity, but it is doing some important governmental function. And many of our public sector organizations and central and state universities are doing that. They're discharging, because government not only does sovereign functions, it also does other things. If you look at Article 298 of our Constitution, you can even be carrying out trade and business. Government has the powers to do that. We saw that in the Ram Javaya Kapoor case. Is printing government textbooks part of government policy, executive policy? And the Supreme Court says yes. And as justification, it relies on Article 298. Okay, so even these activities are governmental activities and can be done by an institution. Therefore, for president and vice president, office of profit is very large. So in fact, if you look at a particular case, Purno Sangwan versus Pranab Mukherjee, where the challenge was to the election of the office of president. It's a 2012 case, and you have a 5-judge bench which explains that when it comes to the office of profit of the president, it also looks at local and other authorities. So at the material time, the president had been a member of the Indian Statistical Institution. He had been chairperson of the ISI. And ISI is a separate institution. It's an educational and research institution, but it was covered under the phrase other authorities under Article 12. And therefore, the question arose whether this was an office of profit or not. So that case deals with that particular matter. Therefore, office of profit is not only for MP and MLAs, but why I'm saying that this is narrower, because local and other authorities are not covered. Over a period of time, if you look at the 1959 law, you will find many exceptions have been carved out by the Parliament. So, chairperson of a cooperative bank, member of public sector undertakings, our own university, membership of the Executive Council of University of Delhi or JNU, etc., would have otherwise been an office of profit. These are not offices of profit. So we have a long list exempting. In the case of Jaya Bachchan, chairperson of the Uttar Pradesh Film Development Council had not been. She had been therefore disqualified. Then came the 2006 law, which gave retrospective effect to these 55 new positions which had been included. So one of the questions in the consumer education research case, which is the citation 2009 volume 9, Consumer Education and Research Society versus Union of India, 2009 volume 9, SCC 648. It's a 3-judge bench, and the question was, can a law have retrospective effect? And as I discussed in yesterday's class, it shall have retrospective effect. Now, if the Election Commission gives the advice to the President that this is an office of profit and the President issues the necessary order, the decision disqualifying the person, this will have effect from the date of the President's order or decision. As I explained to you, it will not be from the point of, are we sharing it with people outside? Is the link working? Priyasha, is the link working?
Yes, ma'am.
Okay. Because I keep getting interruptions. Okay, fine. Where was I? Yes. Consumer Education and Research Society. So the timing of the vacancy. Now, somebody has asked me the question that if a person has been dismissed, we don't say dismissed, we say disqualified on the grounds of holding an office of profit. Is there a cooling off period? No, there's no cooling off period. If the person does not have an office of profit, he or she can stand for election again. But as I told you, for the period before you become elected and become a member of parliament, that disqualification of office of profit will be decided by an petition under the Election Commission. And yesterday I went through different other grounds of vacancies that arise. If it is by resignation, the vacancy under Article 101 will arise from the date that the chairperson or speaker accepts your resignation. If there is a dual membership, the entire listing is there in the consumer. I discussed this yesterday. Let me just very quickly do it again. If you are absent for a period of 60 days, then there are these rules. Then the House will declare by a resolution that this seat has fallen vacant from the date of that resolution. If you have dual membership, both Parliament and state legislature, then there is this prohibition of simultaneous membership rules of 1950. After the expiry of the 60, there's a prescribed number of days. You have to exercise the choice. After that, you will. Name of the case? Okay, name of the case is Consumer Education Research Society versus Union of India, 2009, Volume 9, Supreme Court Cases, page 648. It's an important case. Please do read it. Now, this is also a case dealing with the law of validity of the 2009 law, which added to the 1959 law of what are disqualified. Now, I had also asked, I think, Anjali Tayal to look at Lok Prahari versus Election Commission, which is the 2018 judgment. Lok Prahari 2018 judgment. And this is looking a little further at the Lily Thomas case. Okay. Lily Thomas is dealing with disqualification not on grounds of office of profit, but any of the disqualification based on conviction under section 8.1, 8.2 and 8.3 of the Representation of People's Act. And we have seen the threefold classification under section 8. Under section 8.1, conviction under certain laws irrespective of the period of sentence. And under 8.3, any law but the sentence should be minimum 2 years. Okay, so see the difference. Particular law irrespective of duration of sentence, and under 8.3 any law but the conviction should be minimum 2 years, the disqualification. And then what the Lily Thomas judgment said, Justice Patnaik had declared that henceforth there can be no distinction between sitting MPs and the date of their disqualification and people who are disqualified even prior to them assuming and taking the oath and becoming members of parliament under Article 85. In both cases, disqualification will count from the date that the court convicts them. Yet, only in that particular case, for that members of that Lok Sabha, because appeal had already been filed under the old 8.4, which is now held ultra virus. I'm not repeating it. We've discussed it in detail. Now, what about Lok Prahari judgment? What is it that it explains further about the Lily Thomas judgment? Anjali, are you here? Okay, I don't see her here. So, short judgment, but very nice judgment of Justice Chandrachud. I would require you to read it. What it clarifies is just this very simple point. In B.R. Kapoor's case, okay, remember B.R. Kapoor, where Madam Jayalalitha had been convicted for 3 years under by a normal court, and when she filed an appeal, the High Court had stayed the execution of the sentence. And yes, please.
Ma'am, I have a question. Does the public sector enterprises or the public sector companies will be taken as the same to be get debarred a person from election?
Yes. Yes. Because if they are under the control of the central government, look at the language of article. See, look at the article. Where am I? Let me open 102. I want you to read it again. Holds any office of profit under the government of India or the government of any state. Whereas look at Article 58. Look at Article 58. Under the government of, I'm reading 58, under the government of India or the government of state or under any local or other authority. Now, the definition or the scope of office of profit disqualification is far greater for the election of the president or the vice president. However, what do we mean under the government of India? And if you look at the case law, remember the first case that I took, Shivamurthy Swami's case. Who appoints? Is it done by the government? Who pays the remuneration? If your argument is, Mohit, if your argument is that in a public sector undertaking, this is distinct from the government, and though there may be managerial control of the government over the public sector enterprises, it is a distinct entity. That is a valid argument that you can make. However, if you look at the list of disqualification under the 1959 law, you will find so many public sector undertakings, etc., are listed. Look at the because many.
Okay.
Yes, yeah.
No, I'm sure. Continue. I will later take a point.
No, if you look at the 1959 set of disqualifications, you will see that they list a large number of undertakings which prima facie may appear to be public sector undertakings. But because of that phrase, under the government of India, can be interpreted as under the managerial control, under the financial control of the government of India. A lot of those enterprises, so for example, executive council member of a central university. A university is a distinct entity, distinct from the government. For example, I am a professor here. I'm an employee of the government, of the University of Delhi, but I'm not a government employee. I'm not bound by the different rules of government employees. Therefore, under is a very broad word, and it's capable of both managerial and financial control. And therefore, if you look at the 1959 law and its listing, it lists a lot of these public sector undertakings. Yes, now tell me your next question.
Ma'am, I am Ma'am, if you could, before proceeding to Lok Prahari judgment, ma'am, if you can please explain this again, that when does a seat fall vacant, that what day onwards, in case of a person is disqualified on the basis of holding the office of profit? Because on conviction, the day such conviction is given by the trial court, the seat fall vacant. What happened in the case of holding of office of profit, ma'am? I was not able to understand it.
Okay, I'll just come back to you. Yes, Mohit, what is your question? Yes, Shreya.
Ma'am, does like if we talk about the public sector companies, so would be the government had made a decision, like the judgment had been, any judgment would have been passed, we show that some share of the government will be applicable to become or not to become a member or something like this?
No, nothing like that. It's actually a listing of...
because Samit Patra, currently a BJP MP, is a director of ONGC. So that's why I'm asking that.
Because that listing is there. Look at that 1959 law. It's all been put down there. Open the 1959 Parliament Prevention of Disqualification Act. And it has 2 schedules, okay? One pertains to Section 3, okay? And then, since you're asking the specific question, before I go to the next question that has come up, office or chairman or member of a committee of any matter of any authority or matter of any public importance, etc. Chairman of a syndicate, senate, executive committee, council, court of a university. Any member of a mission sent outside India for a special purpose. Sheriff, armed forces, so you could be in the territorial commission members, okay, and etc. And then just look at this dock labor board. The huge listing is there. And all what you are discussing, right? Board of Directors of National Hindustan Shipyards. All these are there. So you'll need to just check this bodies under the central government, Air India International Corporation. So what I'm saying, that the way the word under the government of India has been interpreted, it includes all these other authorities which are explicitly mentioned under Article 58 and Article 66. So virtually the 2 sets of articles, 58, 66 on the one hand, 102, 191 on the other, practically are occupying the same space, which is why the Parliament Prevention of Disqualification Act 1959, now as recently amended by 66, has literally hundreds of positions that are included, and that's where many of these public sector undertakings are all covered. So, is there a distinction, you began by asking, between an autonomous public sector body and a straightforward government employee? Yes. Yet, the word under the government of India has been given such a broad interpretation in various court judgments, particularly arising under Article 12, that by way of abundant caution, all these public sector undertakings and local authorities have also got themselves listed in the 1959 law. Okay? So just look at it, and then if there are further questions, we'll talk. Let me now come back once to the Lok Prahari point. Okay, look at it and you see what... Okay. Then tell us quickly about Lok Prahari and then I'll address the question.
Ma'am, it would not be possible to complete in 1 minute, ma'am.
Okay.
Ma'am, may I present tomorrow?
Yes, you may present tomorrow. Okay, we may present tomorrow. But I still want to answer the question about timing, which was just asked, so that that question doesn't remain. What about the timing? Now, a person who has been disqualified prior to becoming a member of parliament, that question is going to be decided by a court in an election petition. And that's the important point that I was pointing out to you. If you read the judgment in Consumer Education and Research, and you look at the language under Article 101, Subclause 3, Subclause A, if a member of either House of Parliament becomes subject to the disqualification, look at the English, not became but becomes, मतलब member होने के बाद वो disqualification arise होता है, then the president has the power to disqualify under Article 102 after taking the advice of the Election Commission. Okay. In the case of B.R. Kapoor, the disqualification arose before the election itself, and therefore the person was not qualified under Section 8, Subclause 4 of the Representation of People's Act. That determination is done by a court of law. It cannot be done by the president because that person is not qualified. Now, suppose a person becomes a member of parliament. Excuse me, but the disqualification arose before he or she took the oath. Who will decide that disqualification? Consumer Education Research Council says because it arose before the person became a member of parliament, and they use that word in 1013, becomes subject to any of the. So they say that the president's jurisdiction arises where the cause of action or the disqualification arose after the person became an MP. Okay. But if it arose before and the matter is pending, the person will continue, has taken the oath, will continue to be a member of the House. But the moment the court decides in an election petition whether the person was correctly elected or not, then from the moment the court issues the order under, of course now 8.4 does not exist, but assume that 8.4 existed. Let's assume a case before Lily Thomas. Then the Lily Thomas judgment tells us that the disqualification will arise from the date that the court gave that particular disqualification. And from that date on, even if the person happens to be sitting as a member in parliament, it will take immediate effect. That little extra time that had been given to sitting MPs for them to file an appeal and to live out the term of the House is no longer available. Please remember that a disqualification under 8.1, 8.2, 8.3 of the Representation of People's Act is determined by a court. It's not being determined by the president after taking advice by the Election Commission. President and the disqualification decision based on the advice of the Election Commission deals with those people who have become members and whose disqualification arises afterwards. And that's the significance of the consumer research case. Becomes subject to. Okay? So that is the point. Now, when does this latter case vacancy arise? Consumer Education and Research Society case tells us, suppose in 2015 they became members of parliament. In 2016 they became chairperson of some films division council. Okay, it's 2016. 2017 president takes advice, फिर कोई petition ज्ञापन देता है. 2017 president takes opinion from election commission and gives the final decision in 2017. Did the person become disqualified in 2016 or 17? Consumer Education Research Council says on the date that the president gives the disqualification decision in 2017. Why does it say that? As I mentioned in yesterday's class, if you held it in 2016, and you held the seat to have fallen, deemed to have fallen vacant in 2016, there is another provision under the Representation of People's Act, Section 155, if I remember right, okay, where within a 6-month period, Election Commission is under a statutory duty to fill up a vacancy. Now, only in 2017, President has given decision. It's impossible. Then you're already setting up a case for a violation of the law. Therefore, the court says, in the case where disqualification arose after the person became a member of parliament and the disqualification is decided either by the president under 102 subclause 1 or by a speaker or the chairperson under 102 subclause 2, I have not yet come to that. In both the cases, the vacancy under 101 will arise only when the president or the chairperson or the speaker, as the case may be, may give his or her decision. Okay? So, read the consumer and we will continue again tomorrow. I will have the same link for tomorrow, Priyasha, and we will continue with this live streaming so that people who come late can also get the benefit. And I am closing the class now.
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।